Thank you so much. Good evening, everyone. My name is Ashley Moore, and I will get this set up here for all of us to view properly. Yes, my name is Ashley Moore. I am an attorney at Legal Aid Justice Center with the Youth Justice Program. And the Legal Aid Justice Center partners with the community and with clients to promote justice, eradicate poverty, and with the Youth Justice Program in particular, we do a lot with special education, as well as school funding, as well as juvenile justice, and a mix of topics that are perfect for this evening's session. And as we shared, this is our third session in the series. So we're very excited to present regarding handcuffs in the hallway, but I will allow my colleague Teresa to introduce herself if she wants to.
Hey, thanks, Ashley. Hi, everyone. I'm Teresa Hepler. I'm very excited to be here tonight with y'all. I am also an attorney with the Legal Aid Justice Center, and I work primarily in the Civil Rights and Racial Justice Program, mostly on police accountability work. But I also work a little bit in the Youth Justice Program on school policing issues. We have a really interesting presentation, hopefully, and we are going to have a little bit of an interactive part. So at that point, I'll be asking for some participation in the chat. So hopefully we can get some good participation tonight. Thank you.
So we are so excited. So tonight's presentation is entitled Handcuffs in the Hallway, School-Based Arrests and Referrals to Law Enforcement. And we will go ahead and jump right in. So some key topics. So tonight we're going to discuss the school-based referrals to law enforcement as well as arrest by taking a look at some of the data and particularly looking at the disproportionality that exists for students of color and students with disabilities. We will also be talking about school-based offenses, some of the top ones, as well as what Virginia law has to say about this and the school's reporting duty versus discretion when it comes to different offenses. And then we'll move into police actually being in the schools and, those handcuffs in the hallways and what that means for students' rights. And Teresa will then discuss the student procedural and substantive rights, including search and seizure and questioning. We'll also touch on restraint and seclusion. And then we will end with some parent and advocate tips. And we will also welcome questions at the end, but you can certainly type them throughout, but we are eager to really address them then. So to kick off rather, we have school-based referrals and arrests. We have some stats here. You probably know that data can often lag behind. So the data that we have here is from the 2017-2018 school year. And at that time, there were over 1 million students enrolled in school. And of those students enrolled, 49% were white, 22.4% Black, and 15.7% Hispanic. Of the total number of students referred to law enforcement from school, although the white students were 49% of total enrollment, their referral rates were 39.9%, which is less than their total population. Whereas for Black students, they're 22.4% of the total population enrolled, but they were referred at rates 41.9%. And then for the Hispanic population, they are 15.7% enrolled and were referred at rates 11.2%. And so it's interesting here that you see that, Black students were, of course, referred at almost double the rate of their enrollment. And then those sort of disparities increase when you look at the percent of total arrested. So for Black students, although they're only 22.4% of the population, they were 56.4% of the total number of youth arrested. And white students were 25.8% and Hispanic students were 13.3%. So this was just sort of a snapshot of some of the racial inequality that exists here with school-based referrals and arrest. And there also are disparities when you look at students with disabilities. So out of the entire enrolled population, 15.3% of students have disabilities. That's looking at both under IDEA as well as Section 504. And then for white students, of the population of students with disabilities, 48.6% of those students are white, and 26.8% are Black. And according to the data from OCR with the federal government, that's looking at the students with IDEA. Of those students with disabilities who were referred, or disabled students comprise 32.9% of those who received referrals. And of those referrals, 40.2% of those youth were white and 44.2% were Black. And so again, you see the higher numbers of Black youth being referred, and that's only exacerbated when you then look at the total number arrested. 31.8% of those arrested have disabilities, and then of that, 22.5% are white and 65.4% are Black. And so we just wanted to share some of this data to sort of give a picture of what it looks like in terms of racial disparities, and also the challenges for students with disabilities in this arena. So for school-based offenses, we wanted to just highlight here the top 6 that are captured by the Civil Rights Data Collection with the federal government. You will see here, and again, this data is from 2017 through 2018. The top school-based offense is physical attack without a weapon. That has 23,897 offenses. And so that essentially are fights at school. Fights at school, kids will be kids, but no weapon or anything involved. The second one were threats of physical attack without a weapon. That clocked in at 5,369, followed by robbery without a weapon, which you can see is much, much lower. There were 576 offenses. And then sexual assault actually clocked in at 494, followed by threats of physical attack with a weapon, 110, and then possession of firearm or explosive devices, which were at 102. And so these are the top 6 school-based offenses that again are captured by the federal government with OCR data. And we acknowledge that there are other offenses too. You know, historically in Virginia, there is a big issue with just students, especially youth of color, being charged with disorderly conduct. So that actually led to a lot of advocacy, which led to change. So the law has changed, and we're eager to talk more about that in an upcoming slide. So we want to talk about the criminalization of school misconduct. So there is a duty for principals. They must report to local law enforcement felony offenses that occur on school property or during school-sponsored activities or on a school bus. So, you know, if you're transporting from school, anything related to a school, principals must report if it involves the following at the felony level. So assault and battery are a top one, and assault and battery actually can be couched or considered a misdemeanor. And you'll see down below that principals actually have discretion with misdemeanors. That is a recent change in the law where misdemeanor offenses are optional. However, there's still a chance that if those actions occur on school property, that, you know, your child or your student could be referred. But let's go through the list to discuss some of the other sorts of offenses that can be enforced. So looking at alcohol and drugs, drugs include marijuana, controlled substances, imitation controlled substances, and steroids. There also are some specific ones, including theft or attempted theft of prescription medications, any threats against school personnel, carrying a firearm, conduct with firebombs, explosives, and incendiary devices, and the like, and real or false bomb threats. So again, this is a list that originally included all of them, and with the recent change that gives principals discretion for the misdemeanor offenses, it gives hope that as many kids will not be referred. And there are actually some policies that, if implemented well, could actually help protect students. For example, there is a law enforcement charging option. What this means is that even if law enforcement is notified and referred, they do not have to file a delinquency charge against a student. It's an option. And so if that option is not taken advantage of, that would be to the benefit of students. And schools may actually deal with school-based offenses through graduated sanctions or educational programming as well. And we do recognize and acknowledge that across the state, this is handled differently, the extent to which charging will go forward and the extent to which schools will offer other sorts of programs and options. Importantly, we do want to flag that parental notification is involved here and triggered. So a principal or the designee must notify a parent of any student involved in a reportable incident. So for those list of offenses or conduct that we just discussed, to the extent that your child or student is involved in any of those, a parent should be notified. And this is true regardless or not this is true regardless of whether a law enforcement referral is made or not. Additionally, to the extent that a child is the object of such acts or behavior, those parents are also entitled to notification. It should be immediately reported. And the principal must disclose if the incident was reported to law enforcement. And if it was, then the parents in either instance can then contact the police or courts for more information regarding next steps. And our colleague will actually be addressing what happens at the next step when things do go forward with the court processes. But today we'll be focusing on the school side. And then lastly, with student services, whenever a student commits a reportable incident, each student is supposed to be offered services from the school. And this is another area where we know that across the state it's very different, and students are not always offered such interventions or support services. In some instances, it's fine because maybe they actually don't need them, or in other instances, it might be warranted. And so if they're not offered and you want to ask for those services in lieu of further processing, then it is certainly warranted to ask for that. And we're excited to say that there have been other recent policy wins to help safeguard students. As I mentioned before and sort of previewed, disorderly conduct was historically used as sort of just that last default catch-all to really catch students who might have just been annoying somebody, quite frankly, and they would be charged with just disorderly conduct. But a recent change ended that, such that elementary or secondary school students cannot be charged with disorderly conduct if they are in a school setting. So if they're at school, on a school bus, or at a school sponsored event. And as I said, this is a major step forward. As we were discussing with the numbers, the disproportionality for students of color is exceedingly high, and they often fell into this category of charges. And so with that off the table, that is also hopeful that there'll be more opportunities to stay in school and in the classroom. Moreover, with dress and grooming, there also was a recent change such that students can wear any religiously or ethnically specific or significant head covering or hairstyle. And in particular, this is makes a big impact for girls of color, who in some places were penalized just for how they wore their natural hair. And so it's very exciting to see positive steps being taken to help protect youth. Now, to that end, let's now talk about police in school. So this is the heart of Handcuffs in the hallway. And we acknowledge and want you to know that there are officers that might be stationed at the schools as SROs, school resource officers, or of course, if something happens out of school and schools might not have SROs, when somebody calls the police and the police come on site, that's also another opportunity for police and students to have interactions. Right now, we're just going to focus on SROs in terms of explaining a bit more about who they are and their roles. So SROs are sworn law enforcement officers. They are police officers hired by the local law enforcement agency to provide law enforcement and security services in elementary and secondary schools. They can either be there full-time or they can be there part-time. And the rules governing their behavior and expectations at the school are enumerated in a written memorandum of understanding, an MOU. Schools do not have to have SROs, but to the extent that schools have SROs, then they must have a written memorandum of understanding. And that memorandum of understanding is between the school and the police department. It is very, very important to note that law enforcement officers retain their full scope of authority when they are at schools, except as otherwise restricted by the MOU. So in terms of, being able to have their guns and have other sorts of restraints and strategies, they bring all that with them when they enter the school building, unless otherwise restricted by the MOU. According to Virginia law, the MOU must be published on a school's website. It must be reviewed at least every 2 years. So every other year, it must be reviewed, and it can even be reviewed prior to that, if asked, but mandatorily every 2 years. And during that review period, parents in the community must be provided an opportunity to give public support. And I'm so sorry, I've not mentioned this before, but for a lot of these, we do have the code sections written beside. So if you want to go and learn more about it, you certainly can. Also, another change with regard to SROs, that data collection is required to gauge their interactions with students, including use of force, restraint and seclusion, arrest, referrals, and other encounters. And so data is so important to track what's happening so that you can identify spaces and opportunities for change or reform as needed. And we, of course, acknowledge that there is a big movement to remove police from schools. It's happening across the nation and also happening here in our state. And LAJC has been involved with some of those movements and campaigns. Finally, another good policy change regarding SROs is that there is requirement that for certification and recertification, that they must address topics related to vulnerable student needs, including students with disabilities, as well as just basic and important adolescent youth development, so that they can have that knowledge when they are engaging with youth in schools. And so with that, I will turn it over to my colleague, Teresa.
Thanks, Ashley. Can you go to the next slide, please? Thank you. So first, before I start, I just wanted to give a shout out to the great discussion that I've been seeing while Ashley's presented, that's in the chat. So it sounds like a lot of people here have a wealth of knowledge already. So I just wanted to give a shout out to that chat. So on the topic of police, we wanted to go through some students' rights. So these are constitutional rights, or also known as procedural rights, when it comes to police interactions that might happen between students and the police in schools, in school settings. So just starting out with search, there are two different types of searches, broadly, two broad categories. So there's the frisk, I'm sure you've heard that term from stop and frisk, and then there's the full search. For a frisk, that can only happen to look for weapons. That is a pat down. So literally just a pat down of clothing, nothing super invasive, on the front end, like just going in and reaching into a pocket. And that pat down can only occur if the police have reasonable suspicion that the student is both armed, has a weapon, and is dangerous, going to use that weapon. So reasonable suspicion, what does that mean? Facts, that means the police have facts about the situation that lead to a reasonable belief that the child is armed and is dangerous. And I'll talk in a minute about the difference between reasonable suspicion and probable cause. But mainly with reasonable suspicion, it cannot be a hunch. It can't just be, I just think that this kid has a weapon because I've caught the kid with a weapon like 6 months ago. It cannot be that. It has to be an actual facts, or there has to be actual facts. So just in an example, a child might be having a conversation with an officer, and that child might keep putting their hands in their pockets, keep taking their hands in and out of their pockets. The pocket has a large bulge that could indicate some type of weapon, and the child has exhibited some type of threatening behavior, or what someone might perceive as threatening. those are facts that I just listed that an officer could point to justify patting that child down. In terms of a full search, that's, the searching a locker, the car, that more invasive search in terms of going into a student's pockets or clothing, that sort of thing. Police must have probable cause that a crime was just committed or was in the process of being committed. And so the officers have to have evidence that show it's likely that the child did commit a crime or was in the act of committing a crime. So it's not just thinking facts that might lead you to a reasonable belief. It's actually like, okay, it's actually likely. One example that's pretty simple is officer smells marijuana smoke in the school bathroom, and sees a student throw away a blunt. That's definitely probable cause to go in and go find that blunt. And maybe you search the student for more. And can you go to the next slide, Ashley? So a couple more information about searches. A lot of times when we're talking about searches, people want to know about how warrants factor into searches. And yeah, generally speaking, the police need to have a warrant to conduct a search. But there are some exceptions to that. And before I get too far ahead, I also just want to take a break and just as a reminder, what Ashley said earlier about how the police still retain all of their, they are full-blown police officers, whether they're inside the school or outside the school. And that also means that they are limited by these constitutional rights that students have in the school as well. So I just wanted to make that clear. But these exceptions are evidence just sitting out, right? So maybe an officer comes upon a student in a car in the school parking lot, and there's just a controlled substance sitting on the passenger seat. That's absolutely something the officer can just grab. The child has been arrested. So if the child has been arrested, it's called search incident to arrest. The officer can search the child's person. And also it's something that's called in the legal world, I guess, the wingspan. So you can just imagine. And Jan, I actually am going to get into the administration searches as well. So I'll get to your question. But for wingspan, just imagine it's the full length of, your arms out and then like kind of turning in a circular motion. That's wingspan. So anything that falls in your wingspan, so think a backpack that might be like a foot away from the student, that can be searched if the student is arrested. A child is in a car. The car can be searched, but I say that carefully because an officer will still need probable cause. So an officer will need probable cause to search no matter if it's a warrant exception or they get a warrant. But the probable cause has to be, based on a particular area of the car. Sometimes that can be the entire car. A lot of times it might just be the glove box or the center console. It just depends on the facts. But if a child is in the car and there's probable cause to believe a crime is occurring, the officer can search the car. And emergency situations, which includes the potential destruction of evidence. One of the biggest exceptions to the warrant requirement is consent. So you can see I have in all caps here, a child should never consent to a search. And here's why. I understand that school administrators want children to take accountability for their actions. I know that's part of development and children developing, but oftentimes, especially, I'm just taking controlled substances for an example. If a child has a controlled substance, the school has to report that to law enforcement. And what if law enforcement uses their discretion to bring a charge? Well, then the child just consented to that, and maybe they wouldn't have been able to get in there otherwise. So that's why I say a child should never consent to a search. And I also will say, if an officer is asking to search the child or the child's belongings, that means that they can't get in there otherwise. An officer is not being polite. And I'm not saying that because I'm saying officers are not polite. I'm just saying a lot of people think, oh, they're just being nice. It's not that. They're asking because they don't have a way to get in there otherwise. So if they're asking, that's kind of a key to you. Well, okay, they can't get in there, so I should say no, and that should be that. And if they go in there anyway, that's a problem. So someone had put in the chat about school searches, and yes, there is a big difference there. So with school administrators, they only need reasonable grounds to, yeah, exactly. Kids are not allowed to make mistakes, but school administrators only need reasonable grounds. That's a slightly different definition. It's pretty much the same as reasonable suspicion to conduct a search, even a search of a locker and backpack and anything like that. Basically because school is treated differently. So as I said, and Ashley said, police are police, whether they're in schools or out of schools, and the same laws apply to them. But with school administrators, their main priority is to keep the schools drug-free, safe from weapons, the students safe from harm, teachers safe from harm. So they are allowed to do these more expansive searches and do metal detectors just because of that reason. I will say that school administrators cannot have the police assist in school searches that are only supported by reasonable suspicion. That's kind of circumventing, actually not kind of, it actually is circumventing that probable cause standard that the police have. However, school administrators can also, rather than call the SRO, they can just do the search themselves in the lower level of the lower standard of facts that they need, and then just send whatever they find to the police. So it's kind of a way around that, unfortunately. But I think the key here is don't consent. Children should not consent to a search. Ashley, can you do the next one? Thank you. So that leads us to seizures. So a detention versus a full-blown arrest. So the stop and frisk is what a detention is. It is temporary. The police are basically trying to figure out what is going on and to get more facts. One example might be there is a school fight involving multiple people. There's multiple people at the scene. Rather than just let everyone leave and scatter, the police might hold all the individual students there to try to figure out who was involved. That is a detention, and the police must have reasonable suspicion that a crime is happening or just happened, similar to the frisk part. So with full-blown arrests, it's higher standard, probable cause again. But I will note that just because a crime occurred does not mean the child has to be arrested, does not mean the child has to be put in handcuffs. The child, that part can be skipped and the child can be referred to court. But again, that referral to court will still need a probable cause basis. How to tell in the detention or arrest, what your rights are and whether you can go or not. Child should ask, am I free to go? Can I leave? Sometimes it's unclear. Sometimes officers will approach children just to chat and maybe ask a few questions, but they're not really detaining the child. And it's hard for a child to navigate that. So a child can always ask, am I free to go? Just to clarify, just to make sure they know what they can and cannot do is really important. So the next one, please, Ashley. Thank you so much. So this is the more interactive part. So we prepared two scenarios. This is the first one involving search and seizure. So I'm going to read it, and at the end, I'm just going to ask for people to answer some of the questions in the chat. So officer sees two students sitting in a car in the school parking lot. The officer sees smoke coming out of the front windows of the car and smells marijuana. The officer approaches the students and sees them hastily put something into the center console. The officer asks the students to exit the car and asks to search the whole car. So for my first question is, what could the officer do? And what I mean by that is it okay that the officer approached the students? Is it okay that The officer asks them to exit the car and is okay. First. So Kim, I'm not exactly sure what you're referring to. If you could explain in the chat. But based on what we had, which change is that? Can you just let me know? But in terms of the information I had posted earlier, what could the officer do based on what I had just said the students' rights are? And I'll just give people, a couple. So I have it. So a questioning students is going to be the next part. So this is just about the searching and the seizing students. And then let me go back to this first one. So Kim, I'm not exactly sure about the civil penalty part. This is basically just figuring out if and are you trying to, are you specifically talking about controlled substances? And anyone else, if they want to go ahead and put in the chat, what could the officer do? And then what could the students do? Can the students, officer can ask their ages. Okay. That's a good one. Students can decline. Okay, they can decline to search the whole car. All right. Anything else? What about the officer? All right, so I'm going to go ahead. So the officer absolutely has enough facts. Okay, great. The officer, yeah, that's what I thought. I hadn't thought of that, Kim, and I think that's important. So we can actually talk about that at the end during Q&A. Can you just remind us? But in this particular facts pattern, the officer can ask the students certainly questions about if they're go to the school. And the reason for that is because it's a detention. The officer has facts. They saw smoke coming out of the window and saw them, hastily put something away in the center console. That's certainly enough facts to detain the children to see what else is going on and to ask them out of the car. But remember what I had said about, and somebody had put this in, the students should decline the search of the whole car because what the officer saw, it only involved the center console, right? So I know this was a little bit of a in-depth question, but I think it's important because there's a whole bunch of different layers to these rights, and it just trying to highlight that students should just decline because if the officer's asking, it means they can't get in it. All right, Ashley. Thank you. Okay, questioning. And so someone had brought up about questioning. So that's the next part. This is the biggest piece to my part of the presentation. A child never has to answer questions and really should not be answering any questions if the officer is, trying to get information that the child committed a crime. So that's the key fact here. So if the officer questions a child while the child is detained or arrested, the officer must read Miranda warnings. I'm sure you've heard of those, the right to remain silent, right to an attorney. Regardless though of whether they read the rights, the child always has the right not to answer questions. Yes, it applies to a child. So it applies to everybody, actually. So it's a good question. Everybody has the right to not answer questions. You do not have to ever answer questions. So I'm glad someone brought that up. But I bring this up too because, and I'll talk about this in a couple slides from now, but children have a lot of difficulty not answering questions to the police. to school administrators, to whoever, because adults are authority figures, but I'll talk about that a little later. Parents must be notified before child under arrest is questioned. So not necessarily detained, but if the child's under arrest, they have to be notified before the child is questioned. However, sometimes the parents are not notified. Sometimes it just doesn't happen. And there's not really anything, there's no mechanism to, kind of undo the questioning. So that's kind of it. Okay. If the parents aren't, and it's important because we wanted to let you all know that, because sometimes you all might not be notified. And it is a problem, but there's no solution right now to that problem. And the reason I talk about children answering questions is because a lot of people, especially school personnel, don't remember that confessions, admissions can hurt children in the court system. It is very frustrating for the criminal defense attorneys to get these confessions when they're supposed to be helpful to students and therapeutic to students, to take accountability, as I said earlier, but then they are in the court system and there's nothing that can be done because it's in their defense because they've confessed. So I just wanted to bring that up. And then we have another hypothetical. We don't have a lot of time, so I think I'll probably just run through it real quick. Ashley, we can go to the next one. All right, so just quickly, officer learns from school personnel that a student's cell phone was stolen. This officer sees a child the officer has had contact with before walking down the hallway. The officer thinks that the child may have some information about the stolen phone due to the officer's prior contact with the child. The officer approaches and greets the child and asks the child to answer some questions about the missing phone. So what should the child do? So the child should do two things. No, I'm not going to answer questions. And am I free to go? Right? Can I leave? That's what they should do. Yeah, keep quiet. Absolutely. And what must the officer do? If the officer should just let the kid go. But if the officer says, no, you're being detained, even though that would not be a lawful detention, they have to read them their Miranda rights. All right, can you go to the next one? Thank you. All right, so restraint, and it's actually supposed to be restraint and seclusion. School personnel generally cannot use restraint or seclusion to punish or enforce compliance. Schools must develop policies and procedures that comply with or even exceed Virginia law. So an example of that is that they encourage the use of positive behavioral interventions and supports to reduce and prevent the need for the use of physical restraint, that they have examples of these positive behavioral interventions and support strategies that treat students with dignity and free from abuse. So that sort of thing. They're very strongly encouraged to not use restraint or seclusion, but they can. There's just a lot of requirements regarding seclusion if the school uses it. And then parents must be notified within 7 days of the use of seclusion or restraint. I put this in here basically because to differentiate it with police. Again, police are police in or outside the school. They can put their hands on a child to force compliance. So if the child is confused, not understanding why they're being arrested, the officer might, force compliance, force the arrest. Unlike school personnel, which cannot do that, and they can and do use handcuffs on children. I will also say that the memorandum of understanding between the school and the police department can limit, as Ashley said earlier, the use of restraint, the use of handcuffs, and the use of seclusion, or what happens when the police are questioning a child in seclusion. Okay, next one, please, Ashley. All right, so challenges. As I said, children, especially in my experience, have had a lot of difficulty, what I like to call flexing or exercising their rights to police. The police are adults. As I said, children are expected often to comply and to own up to their mistakes with adults. Police are also authority figures as officers. They have a badge, they have a uniform, they have a weapon. There's also fear of being seen as acting difficult. And this can, definitely be part of a child of color's, internal struggle with flexing these rights. Children with disabilities may struggle even more depending on the disability and situation. As I said, just in the last slide, the child might not understand in general, and then you add a disability to it, why they're being arrested or what's happening. They might have difficulties with navigating the social aspect of having an officer come to them and question them. So one way that can be possibly alleviated is parents spending time with their children, practicing different scenarios. The parent can play the officer and do kind of some of the situations that I had brought up earlier with their child, so that their child can learn what to say and what to do with the police, and just kind of have it be kind of second nature, because it can be challenging. And I think I already noticed this, parents may still not be notified before custodial question. There's nothing to fix if they aren't notified. And also, I will say police may not understand the unique needs of a specific child with a disability. This new SRO law that Ashley brought up earlier does attempt to help with that, so that SROs have special training in how to approach and understand children with disabilities. Yeah, I hear you, Beth. It is important, though, that we are prepared, and that children understand why it's important and how to do it. But that's it for me, Ashley. Thank you.
Thanks so much, Teresa. And I've not been able to see the chat, so there's something that I should be aware of. You can definitely let me know. But we wanted to wrap up and allow some time for questions. I know some people have been asking throughout, which is great, but we just wanted to make sure that we shared some key takeaways and tips for our parents and advocates. As we've said, schools do not have to have SROs, but to the extent that they do have SROs, they must have the MOU and they must have it posted. And so it's very important to check to see if your child's school does have SROs. If they do have SROs, obtain that MOU, read it, and go through, just have an understanding of the environment that your child is going to be in. And then also to be able to, help them enforce rights and protections that might be in there. And as Teresa was saying, it's so important to remind your child to assert or flex their rights when engaging with an SRO or police officer. We know that there are different, contexts and forces at play when they are at school versus, on the street. But while they are at school, they still have that ability to assert their rights. And so as Teresa was saying, it's so important to practice with them, including key actions and phrases. We actually at LAJC have an Our Rights Matter, program in a way. And it really helps equip youth to know their rights and be reminded of their rights. And so we put the 4 steps here that you can walk through with your child so that they know what to do in those situations of police encounter. The first, of course, is just to breathe. You want to remain calm and centered. And so being in police's presence can be very intimidating, especially if you or your family members or community members have had tough encounters with them. It can actually be traumatic or triggering. And so when up close, just want to first breathe, and then 2, ask, leave. Am I free to go, as Teresa was saying? And then, of course, you want to encourage them to remain silent. First say, I choose to remain silent, express that, and then stick to it. And of course, you might have to give some basic information like your name, and you do want to be compliant for things like that. But other than that, in terms of substance, you can assert your right to remain silent. And finally, no searches. You can clearly say, do not consent to any searches. Once that is said, that is legally important, because anything after that, if needed, could potentially be challenged by an attorney. And so it does protect and safeguard your child's rights to say, I do not consent to any searches. And then after that, if anything is found after that, then an attorney would have more grounds to try to exclude what might have been obtained. And so it's breathe, leave, silent, and no searches are the 4 key steps. And if you want to learn more about Our Rights Matter, you can check it out on LAJC's webpage. We also discussed that there are, points when parents have a right to be notified, and you want to ensure that those procedural rights are implemented. And unfortunately, it's harder to ensure that they are followed, because if they're not followed, then you are going to want to, challenge that. But that's important too. So hopefully the school is on its A game to notify you as they should. But to the extent that they aren't, you should document those instances and raise it to the school, or seek outside help as you need to ensure that the rights of your child are maintained, and that you're able to give them the best educational experience. Finally, if your child is referred to law enforcement, arrested, and or charged in court, you're definitely encouraged to seek legal counsel. You could reach out to Legal Aid Justice Center, and to the extent that we're not able to assist, we can certainly help with a referral or whatever is needed in the instance to help meet your child's needs. And as I said before, they have more coming up in the series, and next week we'll actually talk about that next step of if they do have to deal with the court system, what that looks like, what that process is like, and also the role of parents in dealing with that as well. And now we're at our official questions or comments page, or time rather. And I know that we're unable to engage with you face-to-face, but you're certainly welcome to enter more questions in the chat, and then hopefully Teresa can share them as needed.